Hello, my name is Michael Riella. I'm a partner at the law firm of Tannenbaum, Halpern, Syracuse, and Herstrit in New York City. I chair its bankruptcy department, and I've practiced business bankruptcy for about 20 years. Today, I'd like to provide an overview of business bankruptcy, which should be useful to any lawyer or professional whose clients may encounter financial distress, as well as those whose clients may deal with distressed companies as either creditors or contract counterparties or in some other fashion. First, I'm going to talk about the differences between the various chapters of the Bankruptcy Code, and there are several. Just simply mentioning that there's a bankruptcy case doesn't really tell you the entire story. So first, I'll talk about Chapter 7. Which is the liquidation statute within the Bankruptcy Code. And as I just mentioned, it deals with the liquidation of debtors' assets, whether that be a company, a corporation, an LLC, or an individual's assets. Both individuals and businesses can file Chapter 7 for liquidation. In every Chapter 7 case, whether it's a business or an individual case, there's a Chapter 7 trustee who gets appointed, whose job it is to marshal the assets together, at least the non-exempt assets, sell them or otherwise administer those assets, and then pay off the creditors to the extent there is money to do so in accordance with priorities in the Bankruptcy Code. The Chapter 7 trustee is an independent individual who is appointed from a panel of potential Chapter 7 trustees that's maintained in the district where the bankruptcy case is filed. The Chapter 7 trustee's job is basically to shut down and liquidate any business. The management of the company no longer is going to operate the company once a Chapter 7 is filed. In some rare circumstances, a Chapter 7 trustee can ask the bankruptcy court for authorization to continue operating the company for some short period of time. But again, that's pretty rare. Usually when companies file Chapter 7, that marks the end of their business operations. Now, Chapter 7 cases can be commenced in one of two ways. One is it could be filed at the outset. So say a company decides as its initial bankruptcy move to liquidate. That's one way a Chapter 7 case can begin. Another way that a Chapter 7 case can begin is it could have first started as a Chapter 11 reorganization case, which I'll get to next, and the case may be converted to a Chapter 7 if either all the assets are sold to the company or if the company runs out of money or the Chapter 11 case otherwise fails. So there are basically two ways to get into a Chapter 7, either at the outset or as the result of a failed or converted Chapter 11 case. So that's Chapter 7. Chapter 11 is the chapter of the Bankruptcy Code that is mostly associated with business bankruptcies and restructuring efforts. Chapter 11 is the restructuring aspect of the Bankruptcy Code. And there are a number of things that a company can accomplish in Chapter 11. First is a reorganization of its assets, its business, and its financial affairs under what's called a Chapter 11 plan of reorganization. And we'll talk a lot about Chapter 11 plans during this next hour. Another thing that a company can do in a Chapter 11 case is it could sell some or all of its assets. And it can do so either through a Chapter 11 plan or can do so under what's called a Section 363 sale. Section 363 gets that name because that's the provision of the Bankruptcy Code, 11 U.S.C. 363, that authorizes these types of sales.